Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. As of last episode, we have obtained our grant and the associated rights, and we intend to enjoy our rights while keeping in mind the terms and conditions as specified by Section 47, which governs the usage of our invention by the government for its own purpose or by any other person for research and experimental purpose only. Let's revisit the rights once. As per Section 48, a patentee is provided with an exclusive right to prevent others from making, using, offering for sale, and selling or importing the patented product or a product obtained by a patented process. Now, as you can see in the slide, there are multiple applicants, 3 to be precise. In such cases, how do we distribute the rights which comes with the grant? As per Section 50, each patentee, Section 2(1)(p), patentee, each patentee is entitled to an equal and undivided share in the patent. How do we illustrate this using a chart? So as per you, which among these accurately depict the requirement of Section 50? The first one looks a little unequal in terms of distribution, isn't it? But the second one definitely is equal distribution, 33, 33, 33 decimals. So which among these do you think depicts the requirement of Section 50 accurately? Second, isn't it? Unfortunately, no. If your answer was second. Because you are missing out on one important keywords or key requirement from Section 50, which was equal and undivided share in the patent. Therefore, there is no division of the patent itself. There is no division of the right. They have right as if it was granted to only them. But of course, this is applicable only if there was no other agreement that was signed by the patentee among themselves, which defines specific proportions of the rights which are assigned to each of the patentees. In such cases, the mutual agreement that was signed by them always takes precedence over what Act says. In absence of such agreement, each patentee has equal and undivided share in the patent. What does it mean when it comes to enjoying the right? What it means is each patentee can reap benefit of the rights without taking into account others, as if it was granted to him only. 50.2. However, you cannot lease, sell, or let out an interest in the patent or license the patent without the consent of other owners. It's a property. Anything that you do with the property, you need to obtain consent from the others. We discussed from the perspective of patentee. We know there are patented products which would be purchased by others also. Let's look at from the perspective of a purchaser who is buying the product from the patentees. So for him, it doesn't matter if he's buying the product from one of the patentee or all of them. The entitlement after buying the product with respect to the product remains the same as if the patent was granted to one of the patentee only. We know patents are also treated as properties. Therefore, any law which is applicable for immovable properties will also be applicable to the patents. Unless, of course, if there is an agreement which is already in the place which defines the mutual agreement and obligations of the patentees or their legal representative, then such an agreement will always take priority over what the law says or what the Act says. At this stage, we got further clarity in terms of how to enjoy our rights. As we enjoy our rights, there are bound to be scenarios where there will be disputes. Dispute in terms of what can we do with respect to our patent in terms of sale, lease, letting out a share or interest in the patent, or licensing the patent. Few of the patentees may agree to it, others may not agree to it. So there are other legal platforms available for you to sort out such issues. However, Patent Act also provides you with the provision to reach out to controller. As per Section 51, you can reach out to the controller to seek his direction with respect to resolving this dispute. Let's look into the process. So as per Section 51.1, first party, one or more patentees, can reach out to the controller seeking his directions. How do you do that? As per Rule 76, you need to fill out a Form 11 with the statements and the fact for which you are seeking the directions from the controller. Once the controller receives such a request or such an application from first party, the controller passes on the application to the second party, another patentee. Upon receiving such an application from the controller, the second party responds with their own observations, and such a response is again forwarded back to the first party. First party can reply it back, which again gets transferred to the second party. Once this to and fro has happened, controller may schedule a hearing with the second party, but in most of the cases, such hearing can happen among all the parties, the first party, second party, and the controller's presence. After the hearing has happened, the controller issues a direction. In this case, the controller may issue a direction asking or directing the second party to execute an instrument or sign on the document for enabling the first party to enjoy their rights with respect to any transaction that they wanted to undertake. Taking a pause at this point, whenever you have opposing parties at the patent office arguing about a particular situation, then submission of documents, the process, and the hearing takes place as per Rule 57 to 63. This is applicable where multiple parties are involved in an opposing proceedings. Moving back to the particular case. So controller has issued a direction which the second party needs to abide by. What if the second party doesn't agree to it? What happens around that situation? Let's take a look at that scenario. In the scenario where second party is yet to execute the documents as per the directions given by the controller, the timeline that is provided is 14 days from the receipt of the request from the first party. The first party would send some documents for these guys to sign, and they have not signed. In such cases, the first party can reinitiate the process with controller. Same process where Form 11 is signed again with the statements and the fact. Controller sends it to the second party responds, first party again replies, and the hearing happens. Post hearing, controller again issues a direction. In this case, the controller may issue a direction asking one of the first parties to sign on behalf of the second party and go ahead with the direction. See, having discussed both the cases, 51.1, 51.2, remember one thing. Controller cannot issue a direction which would be contrary to any agreement which is signed between the parties, between the patentees already. The agreement takes priority over what the Act says or what the controller says. So Section 50 and 51 provides us with some level playing field and set of rules to enjoy our rights. This brings us to the end of this session. In the next episode, we will discuss the process for maintaining the patent at the patent office and also the process of reviving a patent that got lapsed. So I'll see you in the next episode. Till then, be good and take care.